public domain. You brought up public domain. What does that mean? What is public domain? Tell me, Michael, a little bit about. You're a lawyer, so hip us to public domain. Hip us to copyright versus
trademark, right?
Versus trademark. Give us a little breakdown on that, real quick, if you don't.
I got to go back to the U.S. Constitution, the founding of America. Our founders wanted people to create intellectual property, and they wanted, the citizens of America to have it. But they said, okay, well, we have to inspire people to create it, and they won't create things at the minute they create it. It belongs to everybody. So they created copyright patents. You get a short-term right, an exclusive right that no one else has, and then eventually it belongs to the nation, to the world. So that was the theory of public domain. So for copyright and trademark, copyright, the minute you do something today, if I make a drawing or write a 3-sentence story, I have a copyright. Trademark identifies the provider of goods, the Nike swoosh. The minute you see that swoosh on a product, we all know it's Nike, right? The golden arches, everybody knows who that is. Right. That identifies the seller.
And if I'm right in a minor point, that a trademark doesn't expire, but copyright does expire, or do I have those mixed up?
No, as long as you use your trademark, it exists. If you stop using it, it can fall into it can then evaporate. Someone else can pick it up later. A copyright does expire over time, and depending, I won't bore everyone with it, but the length of a copyright has changed repeatedly in the last 100 years. So back in the golden age, you had to register your copyright. If you didn't file this sheet of paper, you got no copyright. And then it expired, say, 27 years later or whatever. And if you didn't file a renewal, you didn't get your copyright. And if you didn't do everything perfectly correct, you lost your copyright. So a lot of the golden age publishers didn't bother to file. Or if they did file, they didn't renew. Who cares? Nobody wants my comic. It's 68. You haven't published for 10 years. No one's going to pay the money to renew, as Mark would say, Clue Comics 5 or something, so they could have Zippo. Right. Now, I will say that Marvel timely did a pretty good job. I wanted to use one of their homeless superheroes, but they still own them, and they told me they might have use for them. There was a whole 1940s thing of vagabond, homeless hobos, and other superheroes.
Sure, yeah.
So one that I noticed while I was working on a page, and I was like, wait a minute, isn't Blackhawk a DC character? But I noticed him on a page.
He is. So Blackhawk was, I believe, Quality. So Blackhawk and a lot of those, some of the Fawcett and Quality heroes are public domain. People, Shazam, Captain Marvel, some of his issues are public domain.
Right.
And
Bullet
people,
Man, like that. Yeah.
If you're careful and
yeah. No, continue with what you're saying. That's what I want to understand.
If you know what to do. So there are certain characters I'm going to use that people have trademarked. But you're not going to see that character on the cover of my book. You're not going to see the name of that character on the cover of the book. But inside, they're going to be running around. So there's no confusion, and no one's going to buy the comic because on page 20, I have some character who may be trademarked.
Named by name. That trademark character could still be named by name on the interior as long as it's not on the cover. I'm trying to understand the distinction here.
The idea is that you're not using that character to sell your product. That's the idea. That's why DC has such a tight rein on the Superman S, that anybody who uses it anywhere has to really sort of grovel at their feet and hope they can get dispensation, because it's perceived as something that is used to sell. If I do a book about Superman, even a history book about Superman, but I've got the S on the cover, you can make an argument that I'm using their character to sell my book.
Okay, you brought up Superman, Mark. So explain to me then. Superman seems older than some of these characters, maybe even, right? If we talk, Superman came 38, right? So why isn't Superman in the public domain? And can I make a Superman, especially because the name Superman is generic and preceded the character, right? So what do you know? What can you tell us about that, Mark?
According to the law, in the year 2033, you can do your own Superman comics.
Whoa!
But you cannot use the logo. You cannot use the S. You cannot make it look like the character, because that's the difference between trademark and copyright. The elements of that character, the visual elements of that character are trademarked. Yes. So you can do a Superman prose novel if you wanted to in 2033, unless they change the laws yet again to extend copyright. I mean, that's back to what Michael was saying. Copyright was 28 years, I think, renewable for another 28 years back in the day. But Disney doesn't like things to be out of copyright, so they've paid enough lawyers and they've lobbied enough to have congressmen over the years extend that to 75 years, to 95 years. I think it's where it is now. Thank you, Sonny Bono.
And I believe it's something like 75 years, like after the death of, like your descendants get it for a certain amount of time. How does that? It's so confusing.
So again,
Go ahead,
Mark. It all depends on when you created something. Copyright law has changed over time. I won't bore you, but the U.S. joined the Berne Convention, a worldwide convention on copyright. So we changed how we look at copyright then. I told you had to register copyright back in the 30s and 40s. Today, you do not. The minute Mick Gray makes a drawing, it is automatically copyrighted. He can get some extra benefits were he to go ahead and register it, but he doesn't have to. The minute Mark Waid writes a prose story, he's got a copyright. And last, if you'll permit me, in 2033, the Superman that goes into the public domain will be the one from Action Comics 1. So he best not be flying around in space because he can't fly. You know, so
there can't be Kryptonite, there can't be any Candor, there can't be any Supergirl. It's just that, yeah.
So
those
interesting.
will all come later.
Yeah.
Right, and so then as the years go by, then like Kryptonite becomes into public domain, but not from the very beginning. And as I understand, Kryptonite was introduced from the Superman radio show.
Right, that was 45, 1943.
Right?
Yeah.
So anyway, back to our characters, guys. Back to what we've got here. I really wanted to understand the public domain stuff, and I'm almost more confused than ever. To tell you,
than you were going in.
I'm just glad that we have a lawyer running this thing, because that makes me happy, man.
I mean, it's almost like you need that. And okay, and that reminds me, part of this thing, as I look through the stuff, there's a public domain guide that is coming out as part of the project, or is that just loosely affiliated? Explain to me what that is, Michael.
Okay, so it's really just okay. So there's the 100-page graphic novel. Then we did one-pagers of a bunch of the heroes in the books by various artists like George Perez and others. We had a one-pager of villains. Then we did, let me see. We have a source book. So the source book is really a description of some of their 1940s adventures. So people would have even more backstory on some of these characters, where we really summarize what actually occurred in the 1940s comics.
Michael, let's talk about, again, I hate to keep coming back to this public domain stuff.
I knew you were doing that. That's fine.
It's so intriguing. I got a lawyer here. I got a comic book lawyer here, and we're talking public domain characters. Right. So I want to understand, if I wanted to put out a Catman comic tomorrow.
You can. So let's do the Black Terror.
Yeah.
Black Terror's in a bunch of comics. Dynamite's got a Black Terror, right?
Yes.
I'm going to have a Black Terror. Well, how can I do that? I got the 1940s Black Terror. If you look carefully at Dynamite, they changed his eye mask a bit. That he has a different backstory. So I couldn't use Dynamite's origin for their character because they're not using a 1940s
or
origin
any
necessarily.
Design tweaks that they
correct.
Might have
Those design tweaks are copyright and not in the public domain. So, I mean, mine are based on the 1940s characters. But yes, you can do a Catman comic tomorrow.
But then as soon as but so then you put your Black Terror in there and you based him on the 40s, but like if you made one tiny change, did that then become Michael Finn's Black Terror? How does that work?
So
somebody asked a question about open source characters and how does it work in that regard? Like if somebody wanted to take like Red Liberty Brigade and were inspired by those characters and said, I want to put this out, where would be the limits? Where would Michael Finn come after them if they
couldn't call them the Liberty Brigade? Couple of the characters I created, they're mine, so they couldn't have those. Being the clever lawyer, let's just assume I trademarked one or two, so I best not see those characters by name on someone else's cover. But they could take those characters and put them in a book and do what they wanted. A really famous case was Sherlock Holmes, right? There's all these books about Sherlock Holmes, his buddies Watson.
Yes.
One of the early stories was in the public domain. They didn't copyright it. And so someone wanted to write more Sherlock Holmes stories, and there's a big lawsuit. And the court said, no, this Sherlock Holmes is in the public domain. Watson, he's not in that book, so Watson's off limits. And the fact that I think Sherlock Holmes was a boxer, that's not in that story. So don't be talking about that. You only have, so when Mark's example, if the Superman of Action Comics 1 falls in the public domain, the Superman that looks like that has that power set. You can't draw him like John Byrne drew him, and or George Perez, and he's flying, or that those powers in that depiction didn't occur till much later, and that version won't hit the public domain till much later.
So that's my question. So then if I put out, Action Comics goes into public domain, Action Comics #1. Right. I write a story, and on my cover, I've got, it doesn't have the classic Superman S, but it's a dude with an S on his chest or whatever. It doesn't violate the copyright. But then inside, I have my young Superman learn to fly and do things that happen later. Not necessarily kryptonite or anything copyrighted, but just like things start happening that are more like Superman. Is DC going to be able to come after me because of that?
Well, I'll come after you for two reasons. So first, let's just say the cover of your comic says, this inside is a cool story. So we don't have to worry about trademark, right? Where if you have the character on the cover and DC has a trademark, again, trademarks identify the originator, the seller of the product. So if the character, then people will say, oh, they're confused. They thought it was DC. They didn't know it was Dan Shaheen Publications. So let's just say your cover just says, inside is a cool comic. Yes, your character can look like the 1930s Superman once he's in the public domain. If you start having them do all the things that Superman does now, they'll probably come after you. But if you are doing the 1930s version, you'll be fine when that becomes in the public domain.
It almost seems like subjective. Like if you were to put it out and have him do, I don't know, he uses his super breath, which didn't debut until 1957, right? Or whatever.
Right.
And like, it's all going to depend. Well, how much money did this guy make off it? How much attention did he get? Did the right person see it? And then did they decide sit down with a lawyer and say, super breath is our thing. We're going to sue this guy into oblivion for but obviously they could sue for anything. Anybody can sue anybody for anything. But what would be in that specific scenario? Would I have a legal leg to stand on?
Well, I mean, okay. The question is always, how much did you appropriate of what's protected, right? If I made a tweak and just, I don't know, I put a little tassel on a character, the court may say that's just not original enough to take this public domain character, that your version is just not that original, right? I mean, if I took that TNT Todd and my TNT Todd flew around with a cowboy hat and a pistol, okay, that might be original enough that you can't do that. But, if I just change his glove a little, you can do the same thing. I mean, as you point out, it's all about money, right? If you do something and you sold 2 copies, you're probably not worth doing more than writing a letter that says, hey, please don't do this anymore.
Right, because, well, then is the danger that, so let's say I did it and it sold, 100 copies. And DC didn't put anything out. Is that then now like a legal precedent that they didn't protect that, so now it's fair game? Or how does that piece of the puzzle work?
So, boy, you really love getting into this. I
do.
If it's a trademark, you have to protect your trademarks. So DC, if you were violating a DC trademark and they do nothing, their trademark can be considered weak or even lost. So they're compelled to protect trademarks. Copyrights, I have a lot more choice whether I want to go after you or not. And as you know, there's all these cases where people compare, well, how much was taken? Is this story original or not? There's something called stock scenes, stock situations. Boy meets girl, boy loses girl, boy gets girl. That's a stock situation. Nobody can copyright that. How it happens, where it happens. So I hope that's helpful. I mean, it's a real thicket. I hired some law students and a professor at GW to help me to make sure that the characters I wanted were in the public domain, that I could use them. And 1 or 2 times where I thought I couldn't, I changed the name. I really wanted to use a hobo character by Marvel, so I couldn't. I just so I created a different hobo character.
Fighting hobo or something, right?
Yeah. There's, I think, was the battling hobo or vice versa.
Oh man, I want to read that for sure. It's just very interesting to me because in this litigious world, in this world where it costs a lot, like it's great that you're a lawyer and you can do this, because maybe then people are going to think twice about just like suing you for the sake of suing you. You know what I mean? Just to keep your thing out of the market. That seems like a real danger if you pursue these kind of public domain type projects like Conan,
right?
H.G. Wells stuff. There's a lot of examples of that. Well, and Mick, did you get your samples? Did you get your desktop sharing to work, Mick?
Yes, I'm ready.
You can share them whenever you want. We can keep talking and we can bring the screen up.
Yeah. Go ahead, Mick.
Okay, I'm going to bring it up. Can you see me?
Not yet. But anyway, Michael.
Yes, people threatened me, and I said, "Hey, great. I really want you to sue me. This will be terrific because I think your characters. I think you have no rights to them. I'm going to prove it." And I was an appellate lawyer, so great. If I lose at trial, this will be awesome. I really want to get there, and I know all these pro public domain groups. They can't wait to come play. Yeah, please go ahead, sue me. And everyone's like, you know what? This guy's probably not going to sell. You know, I don't want to be a major publisher. I want to sell a couple issues. I have a couple issues of this story to tell, and each one's self-contained. But we're going to tell our story, and if people want to come threaten us, that'll be great. We'll go.
That's where I go. You know, if I see a guy and he's a lawyer, and you obviously did the research and did it. There's still lawyers out there. There's still unscrupulous people out there who are going to say, let's just sue the guy and just bury him in lawsuits.
Well, they could, but here's the thing. The good news is they have to prove certain things. So let's say, I don't know. I don't want to use DC, but let's say there was AB Comics. And they said, oh, you know, we own this character. I'm like, great. Show me your registration document from 1942 in your first issue. Show me it for every single issue. And if you do, I'll change it. We want to respect people's intellectual property. But if as I believe, you didn't protect it, get out of my way. And some of them are going to back down because they know they didn't protect it. And they don't really want to be in a courtroom finding out that maybe they don't actually have rights to the character that they want. So we respect people's IP. We really did go look to make sure they were in the public domain and wanted to be really thoughtful and careful about it. We didn't get to use a few characters that we would have liked to.
Basically, though, because you could not prove that it had lapsed, that they're
one or two were owned by major corporations that aren't even in comics and probably don't even care. And I doubt they even look. I'll be honest. There's some character buried in the book, and I'm not going to say who. Where I know a major corporation who has nothing to do with comics and hasn't for 50 years. They still hold the copyright. And I was like, I don't care. They're just not going to do anything. But for Marvel and DC, they're in the business. I mean, they inspired me. They created my. I don't want to pick a fight with them. If I saw they had a character and they own a trademark or copy, we just pick someone else. There were so many of them.
Michael Finn, what a knowledgeable guy, not just about comics and Golden Age stuff, which he's super passionate about, but I got to pick his legal brain a little bit too on this public domain stuff that I've still got a bunch of questions. I might have to go back there and talk to him a little bit more.